Christine, your Florida family law attorney, and I'm here for one more question. So I'm ready for my divorce and I've filled out all my paperwork. Now what? How long is it going to take? Well, I'm a very literal person, so I really like to explain exactly what happens once you've decided to retain an attorney. Because the thing is that it's not as quick as you think. You don't go, okay, well, I'm done with this relationship and I'm ready to move on, so therefore let's get this paperwork done and let's get it over with. It's not really how it works. So once you've decided that you are ready for a divorce, or the other side has decided that they're ready to divorce, there are two different types of scenarios. But let's start with, you're the one who has decided that you're ready for a divorce. So you've interviewed all sorts of different attorneys, you've decided that this is the attorney that you want. So normally what you'll do is you'll fill out an agreement for representation or a contract for services. So you've paid the retainer. Next step is the attorney will have you fill out an initial questionnaire. It gives your name, your address, your social security number, your date of birth, your children's full names, your children's date of births, your children's social security numbers, all of the addresses that you've lived at, your spouse's name, full name, middle name, date of birth, social security number, address where he or she lives, jobs, employers, pay rate, what about the benefits, health insurance, how much do you pay for health insurance for yourself, or you, your kids, and the other spouse? What kind of cars do you have? Boat, wave runner, jet skis, four-wheelers, campers, trailers, RVs, rental properties, timeshare, anything that you can think of. Every single thing that you have in your name, everything that's in your spouse's name, everything that's in both of your names, all of your children, all of your property, all of your assets, all of your debts. What kind of credit cards do you have? How much are the balances on the credit cards? Where are your joint accounts, checking accounts? Where are your individual checking accounts? Everything. So this questionnaire gives every single detail that you can think of. And that questionnaire only goes to the attorney. So the attorney takes that information, and then what we do is we draft all of the pleadings, your petition for dissolution of marriage, your UCCJEA, your notice of Social Security, your financial affidavit, mandatory disclosure, notice of Social Security, all of the pleadings, initial pleadings that we have to do in order to file for your case. But we draft all of those pleadings and then we call you back in and we say, okay, here's everything based on your questionnaire, that everything that you filled out, here's all of the pleadings that we've done. Once you've made sure that dates of birth are right, social security numbers are right, names are spelled right, and all of that sort of stuff, you sign it, paralegal notarizes it, and at that moment, your second retainer, which goes into trust, is for costs, like the filing fee. Because in order to file for divorce in the state of Florida, there's a filing fee. In order for the other spouse to get served, there's a process server fee. Then the attorney files it over at the clerk's office. Takes about 24 to 48 hours to get a case number on it. Once you get a case number, the pleadings go to the process server. The process server normally takes probably about a week to actually serve the person with whom you're wanting the divorce from. Once that person is served, the time clock starts ticking. They've got 20 days to respond, or they don't respond at all. But after those 20 days, on the 21st day, we go and we file a default. And we ask the court to say that even though we have served the other party, they have not participated in this action so far, and we want to default them. So once the default is entered, we don't have to go to mediation. We don't have to do anything further. Last thing that we have to do is set a hearing in front of the judge. We go in front of the judge and we tell the judge what we want and how we want it resolved, how we want the divorce, how we want all of the property, children's disputes, everything done. Final judgment, and you're done. Now, if they do file an answer saying that we agree with this, but we disagree with that, all right, then we need to go to mediation. And if we're going to mediation, then we can decide, well, we'll give here, you give there, and we try to figure out how we can resolve things without leaving it up to the judge. If mediation doesn't work, then we go in front of the judge and we argue to the judge what we want. The other side argues what they want, and then it's up to the judge. But it really does take some time, because even you've hired an attorney on Monday, you're still looking at 2 to 3 weeks before you can get all of your pleadings ready to go. And then once it goes to the process server, it's still about another week later. And then the other side, once they get served, you have to wait 20 days. But if they do respond, then that means that we have to wait for financial affidavits and mandatory disclosure, mediation. So you're looking at least, at a minimum, maybe perhaps around 6 months. So things don't happen as fast as you think, but they really do happen fast. If you do have any questions, please give me a call. I'm happy to help. I'm Christine, your Florida family law attorney.